Hello YouTube, MikeLibertarian here. Our friend Hubris316 has now abandoned his so-called secular case against homosexuality, neglecting his video on homosexuality under the law in the process. He has done so cloaked in the will of his fan base and claiming that he is tired of saying the same things over and over again. I guess I should applaud him for finally sticking to democratic principles. But repetition alone does not equate to truth. However, don't tell Crazy316 that. His whining amuses me. If in claiming he has already said it all before, is Hubris316 suggesting that his late-term aborted video on homosexuality under the law wouldn't offer anything new on the subject? That he has already forwarded the arguments he intended to include? Let us then look at what he said in the past about homosexuality in relation to the law.
This man once said, if you're a contractor, you use the 1099 tax form. A person who is an employee uses a different tax form.
By wise man, you mean a friend of yours here on YouTube, whose metaphor contends that heterosexuals are like the boss, while homosexuals are like the employee, who both apply for different sets of paperwork. Okay, what aspect of this system leads you to conclude that equality exists within it? I hope you have something better than this, so let's search a little deeper.
The 10th Amendment has been upheld that the state may define marriage and be separate from other states.
The 10th Amendment of the United States Constitution says, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." By this, are you trying to say that legislation like Prop 8 is constitutional? That the natural rights of a minority group exist at the pleasure of the majority? That is not what the Founding Fathers had in mind. They established a system of majority rule with minority rights protected. The very same argument you are using today, by citing the 10th Amendment in this context, was used by the pro-slavery advocates in the 1840s, 50s, and 60s.
Anybody who tries to compare blacks to homosexuals needs to be shot in the face. Period.
I'm aware of your knee-jerk emotional responses to this, but have you managed a real argument?
Now, according to the United States government, to be considered for minority status, a group must meet several qualifications in which homosexuals just don't meet. Yet the blacks of the civil rights movement highly qualified for.
Homosexuals are using not only the language, but they are beginning to insist that the statutes, the laws, all of the advantages gained by civil rights leaders such as Martin Luther King be now applied to homosexuals.
So, the propaganda piece you cite in turn focuses on a U.S. law which is purported to have defined what a historically oppressed minority is. It does not change the fact that homosexuals are a statistical minority, and considering the amount of hate crimes perpetrated against them, including, among many others, the death toll which I informed you of in my last video to you, titled Out Damn Spot, to say that homosexuals are not historically oppressed would be a denial of the facts as well. This law is not the be-all end-all and is not eternal. It is wrong and should be changed. In the meantime, it actually has little bearing on whether or not homosexuals should be afforded their rights to marry. Only that to claim that they are not historically oppressed minority and then turn around and deny them their equal rights by majority vote is a contradiction. What else you got?
Homosexuals have equal rights under the First Amendment, the 14th Amendment, and the state constitution of every state in which they reside.
The 14th Amendment to the Constitution of the United States, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, or shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the law. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any male members of such a state being of 21 years of age, the citizens of the United States, or in any way abridged except for participation in rebellion or other crime, on the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear the whole number of male citizens 21 years of age in such a state. Section 3. No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States, or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid and comfort to the enemies thereof, but Congress may, by a vote of 2/3 of each house, remove such disability. Section 4. The validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned, but neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss of emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. Section 5. The Congress shall have power to enforce by appropriate legislation the provisions of this article. First, what it does not say. It does not expressly define marriage as one man and one woman. In fact, it doesn't even mention marriage at all. But what does it say? The relevant passage, I think, is to return to Section 1. Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of law. So, to deny anyone equal rights is unconstitutional. So, legislation like Prop 8 is unconstitutional. Hubris 3:16, you lose. But allow me to explain how. You see, heterosexuals are physiologically attracted to the opposite sex, yes? And they often fall in love with members of the opposite sex and propagate the species with them. How convenient for them, who are allowed to marry those whom they are physiologically attracted to. This convenience, this right, this liberty is denied to homosexuals.
Homosexuals have every right to marry the opposite sex just like I do. You can twist that any way that you want to. The fact remains the same. They have that right. Period.
You're not really one to follow through with your own logic. And by the way, you are the one who has twisted things. As I said before, following your own argument, when homosexuals are finally granted their true equal rights, they will not have received special rights, because heterosexuals too will be able to marry the same sex. The reason you refuse to recognize this state of affairs as equality is because you have no use for same-sex marriage. Yet you claim the current state of affairs constitutes an equal system, though you ignore the fact that homosexuals equally have no use for opposite marriage. Congress shall make no law abridging the right of the people to peaceably assemble. More than just protecting public protest, this clause of the First Amendment protects the freedom of association. Furthermore, there is another amendment in the U.S. Constitution which you have conveniently forgotten, the 9th Amendment, which says, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.